Recording in progress.
Сіли зачекати, поки зберуться трохи люди, бо їм некомфортно виступати. Починайте. Ні, ну в принципі 9:15 по крайній почать, щоб вони це. Якщо ми спізнимося на півгодини, все.
Спікери долучилися, все нормально.
Мастер вже приєднався.
А що з
Крес
сенсом?
ще? Да.
Ні, крест тут.
Да, сенс.
А ви з Зеро на зв'язку? З Зерою Козлею, ви на зв'язку? Він ніби приєднується сенс зараз. Просто я ж не можу з ним зараз бути на зв'язку.
Hello? Hello, Mr. Sands? А він буде його чути? Да, він прийде. Hello? Can you hear me? Mr. Sands? А ми їх не чуємо. Чути, да? Yes. Mr. Sands, can you say something? Вони нас чують, це можна перевірити?
Ми написали.
Так, ні, він просто нічого не відповідає, да?
Да.
Ну це ж мене і турбує.
Я чув, я виставив.
Mr. Sands, can you hear, can you hear me? Mr. Hofmeister,
1-2.
good morning, do you hear me?
Ladies and gentlemen, please take your seat. Our conference will start in a few minutes. Шановні учасники конференції, будь ласка, займайте свої місця у залі. Ми розпочинаємо за кілька хвилин.
Mr. Hofmeister, Mr. Sands, we will inform you when you will connect to our panel, so be ready. Thank you. Mr. Sands, Mr. Hofmeister, can you say something to check the sounds? Оно не включилось. Чому їх не чую? Can you say something?
Не бачу я. Нема
Ви
такого.
написали? А, да.
Ти йому особисто написав.
А, і треба.
Hello to live.
Oh, hello, Mr. Hofmeister. Good morning. Hello. Yes, thank you for joining us. We can hear you. It's great.
Yes.
You can hear us. You can see us.
Testing,
yes?
testing, testing. London Heathrow calling.
Same from Brussels here.
Did you just get off a plane from DC 5 minutes ago?
Mr. Sands, Mr. Hofmeister, everything is okay?
1-1. 1. Ladies and gentlemen, please take your seats. We're starting in 1 minute. So you're ready, gentlemen? Okay. So, good morning. One more time, I'm glad to welcome you to the second day of United for Justice Summit. Today we will have a productive day, I hope. We will have 3 working sessions with 6 discussions panels in it. And actually, yesterday we also were pretty productive, such a productive that I forgot to introduce myself. My name is Bogdan Mashai. I'm Ukrainian journalist and TV presenter, and I'm the host of this conference. So we're ready to start our first panel, but before that, please stand up to remember those brave Ukrainians who lost their lives in this cruel war, with a minute of silence. Thank you. So the first panel is rule of law versus rule of force, prosecuting the crime of aggression. Panelists are Urman Sreinsalu, Minister of Foreign Affairs of the Republic of Estonia; Andriy Smirnov, Deputy Head of the Office of the President of Ukraine; James Goldstone, Executive Director of the Open Society Justice Initiative; Klaus Kress, Professor of International Law and Criminal Law, Director of the Institute of International Peace and Security Law at the University of Cologne. Also, we will have Philip Sands, KC, Professor of Law, Director of the Center of the International Courts and Tribunals, University College London, and Frank Hofmeister, Director for General Affairs and Chief Legal Officer of the European External Action Service. They will join us by video call. And moderator of this discussion is Anton Koronevich, Ambassador at Large, Ministry of Foreign Affairs of Ukraine. We have 75 minutes scheduled for this discussion, so gentlemen, take your time.
Thank you, Mr. Presenter. I'm sorry for this technical issue. I'm not good at techniques. Your Excellencies, distinguished colleagues, ladies and gentlemen, it's a great pleasure and honor today to be here today with you in Lviv on this great conference organized by Prosecutor General's Office of Ukraine, and having collected here in Lviv so many stakeholders working on accountability issues. And it is so important for, I think, all of us sitting on this panel, for people who believe in accountability, in particular in ensuring and securing accountability for the crime of aggression against Ukraine, to be, I would say, continuing what yesterday started on the highest possible level in the remarks by Mr. President, by Mr. Prosecutor General, by Mr. Head of the Office of the President of Ukraine, by our colleagues from different states, from different governments, that the accountability for the crime of aggression must be ensured, and there shall be a special tribunal established for that purpose. And today we shall discuss this issue with our distinguished panelists, why it is important from their perspective, from perspective of their professional expertise and their governmental or expert academic position. And of course, I'm more than happy to start the discussion with a big friend of Ukraine, a brilliant lawyer, Minister Reinsalu, who leads the Ministry of Foreign Affairs of Estonia, And Estonia really is with us from the very first day on all the issues in relation to accountability, and in particular on the issue of accountability for the crime of aggression and establishing the special tribunal. With such friends as our Estonian friends and colleagues, we are definitely sure that we will succeed and everything will happen. So Minister Reinsalu, if I may, why it is so important for you personally, for Estonian government, for Estonia as a close friend and partner of Ukraine, to be leading this track together with us and to push this issue of establishing the special tribunal for the crime of aggression in different international platforms and fora?
Yes. Okay. Good morning, everybody. You know, Anton, we first met just days before the large-scale war started. And you were then President's representative to Crimea. And we were in the start of bridge from mainland to Crimea. And I asked you, if the Russians come, will they come in the late evening or early morning? And we discussed about accountability, how universal accountability principle should be established. Surely the sole juridical, legal responsibility will lie on Putin regime, on Russian Federation for this war, which has continued for 9 years. We have to put it to the perspective. And before that war, there were domestic terror, there was Georgian aggression. But we should ask from ourselves what we, world countries, didn't do that this war take place. Why is that so? And this gives us a particular responsibility and duty to act. Accountability is a lakmus. If we, the free world people, will look in the morning to the mirror and answer who we actually are we worth of these values, what we so euphemistically like to present in a daily business in peaceful times? Or are we still afraid of defending the values what we are believing in? So accountability issue is not solely the issue about Putin, about Russia. It's about the martyrs and innocent victims in Ukraine. This is about us. All the world countries should give the answer properly, not falling into euphemisms. There's a very good and solid support to accountability as a principle, but enough of euphemisms. Now we need action, a practical deliverables and concrete pathway, how to make a paradigmatical difference. We failed on accountability in a near past, and it has encouraged aggressor. It has, feed its appetite. And the core issue, I think, is accountability is very much needed, surely, also for Russia, for Russian future, for Russian people. As we do remember the times of after the Second World War, also the basis of a start of finding itself a peaceful future, it's most important for Russian society also, a vital issue, who the Russians are in future. And accountability, from the third angle, is a moral issue, but this is also a security issue. If the aggressor will not pay the price for the crimes will repeat itself in a new manner. We in Estonia know the price of totalitarianism. In the both as Nazi and communist regimes, our demographical losses were around 1/5 of our population. So it's very easy calculation. What's the price of freedom? And if not anything abstract, 1/5. And actually putting it to the larger perspective, the world was capable to give a proper answer, response to the Nazi crimes. But the world community did fail, and the Russian society did fail, to give a proper answer to the totalitarian communist regime crimes. And again, the one thing is about justice, but one thing is about prevention. I can't imagine if Russian society would have also a certain awakening with its past, that KGB colonel lieutenant would ever become a new totalitarian ruler of Russia. And the justice, I think, begins from the truth. The truth is that there is a genocidal intent in that war, to put it to the proper perspective. And speaking about admitting it, there are only few cases where world parliaments have recognized it after the appeal of Verkhovna Rada to recognize it as a genocide. Estonian parliament was the first one. And why is that? Is it a legalistic issue? No, it is an issue of politics. President Macron put it to the very proper context. From last April, I remember his words. He said, if we recognize it as genocide, it will mean that we need act more, and it means escalation in that context. Because remember this Genocide Prevention Convention. It asks the state parties of convention to take any measures to tackle and end the genocide. And this Genocide Convention gives also obligation to the countries who see genocide to inform United Nations on that matter. Last September, I turned officially also to UN and said, Estonia sees it as a genocide. It's a genocidal intent. It is not solely an issue of taking control, physical aggression, of taking control over territories. The intent is not just physically annihilating, well, houses or human beings, but there is also intent to annihilate Ukrainian nation and Ukrainian culture. And so, on tribunal and accountability, you know, after the Bucha and Irpin events, I gathered together a group of international law, humanitarian law, war law experts, and I asked them, please draft me a tribunal statute. And pick the most reasonable model, what also international community could be, in a way, in theory at least, deliver. And they prepared basically a Sierra Leone statute. Then I took it, I made explanatory, asked them to make explanatory note. Then I drove to Kyiv. I gave it to Ukrainian Minister of Justice, to other people. But this was just an exercise. But now the year has passed, and these have been tectonical times and paradigm-changing times. And are we capable now, in the sake of our children, grandchildren, generations, in the sake of Ukraine, but in the sake of Europe, in the world community principles, also deliver? And this is a very important question. My clear message is, we need to deliver, not just speak abstractly about accountability. we need to create, on the basis of UN General Assembly mandate, an tribunal. I spoke last week with UN legal counselor. He said it is purely a political issue in the hands of member states. Legal basis can serve, but the intent should be first. Political intent should be. And all the politicians, all the governments, all the countries who say it's in the hands solely on lawyers to deal, there are differing options, different angles, they are actually afraid. And why in many cases they are afraid? Of course, it is a lakmus. How you can maybe in future call to Putin if Putin needs to be sit in New Nuremberg. This is a very basic issue. And this is also lakmus. Can the world community imagine that after the end of this war, we will return to the normality of international relations with Putin regime? This is a basic question. And again, not question about Putin, not question about Ukraine, but it is about us. Can we imagine that? And even if in the midst of war horrors, in the midst of atrocities taking place, we are not capable say what we think and politically deliver, I think it is a big question mark on a responsibility we should not fail. If we intellectually, morally fail now, it means that we have not repeated from, we are not learned from the past where we made it possible not that the war take place. And so this is an issue of courage and understanding that the world is changing, the paradigm is changing, and we need to make these going a new world order principles. And we need to live in the times of courage, not appeasement. Appeasement time is ended. Putin ended it. And now we need to act. This is my sole message here today. Thank you.
Thank you so much, Mr. Minister, for that. And again, for all the support Ukraine gets from Estonia, in particular on accountability track. And I think that many of the issues which Minister Reinsalu raised are very important for us participants of this conference. We all want and need practical deliverables, in particular in this issue of the special tribunal. We need to get further on from political support to concrete legal job. And that is why it is so important that this conference yesterday was opened in particular by Mr. Prosecutor General with saying which practical results this gathering will have for concrete legal steps. Always it is important to talk, but it is important to deliver. And so that is why we are on the same page on this issue. And the idea that the special tribunal and the responsibility for the crime of aggression is responsible for the Russian nation itself. I think this is something what we heard in Berlin, that a Nuremberg tribunal was a gift to German nation. And with that, we need to ensure accountability for the crime of aggression. Thank you, Mr. Minister. Я маю велику честь надати наступне слово пану Андрію Смирнову.
A pleasure to give the floor to Andriy Smirnov, Deputy Head of the Office of the President of Ukraine, a distinguished lawyer of Ukraine, very experienced lawyer of Ukraine, who deals with the issues of legal reform, law enforcement in the Office of the President, and he is in charge of creating special tribunal for the aggression crimes against Ukraine. He is the coordinator of the task force created by the order of the President Volodymyr Zelensky, and this task force is responsible for this issue on behalf of the Ukrainian government. So the question to you, Mr. Andriy, and the question is probably obvious for the audience here. Why for Ukraine, for the Ukrainian government, for the office of the President of Ukraine, certainly, for the Ukrainian legal community, the issue of accountability for crimes of aggression and the issue of creation of special tribunal is really the highest priority, and we hear about it from the head of our state.
Hello, Anton. Esteemed friends, ladies and gentlemen, it's a pleasure to be here. I am very excited over these 2 days, and I feel I'm amongst my colleagues, professionals, writing history, writing global history these days. I recall the 24th, the 25th of February, a year ago, when Anton and myself had the idea of charging for the crime of aggression. We received odd looks from the leadership. The priorities were shifted, of course. But it was apparent then that the crime of aggression cannot be placed hostage to policy, regional policy making or global policy making. Tell us, have any of you lived next door to a maniac that wanted to murder you or rape you every passing day, crash your home? Ukraine is living next door to such a maniac over the last few centuries. This is a country alone that made 3 attempts to destroy the Ukrainian population through genocidal famine. It's a country that has organized purges, political repressions. The country that in 2014 invaded the Ukrainian land, having committed the crime of aggression, because the crime of aggression did not begin on the 24th of February. We know very well it goes back to 2014, when they attacked the Ukrainian Crimea and Ukrainian Donbass. Then the policy came next. As a lawyer, I'm in a position to make assessments and say opinions that no negotiations, no agreements had any sense, because the primary crime was committed. The crime of crime was committed. For over 70 years, the global history has not seen bringing countries to account for the crime of aggression, which let the dictators and crazy maniac the freedom to conceive some crazy land grab ideas as for the neighboring countries. I remember very well when Anton and myself looked into the methodology of running the Nuremberg Tribunal, the Tokyo Tribunal. I remember reading the UN Charter, rereading the Rome Statute back to cover, and I'm happy that before my eyes, over this year, starting with the concept of accountability for the aggression crime, the idea has evolved into the readiness of the civilized world to hold the perpetrators to account, because the maniac will attack yet another country tomorrow. They will come to kill, pillage, rape, and destroy. I'm not going to say that it's been an easy year for us. We had to grapple with a lot of skepticism. We had to overcome a lot of mistrust for the idea. You know, any immunity that often the political leaders may have do not stand when the crime of aggression is committed. The functional duties of no head of state has the duty to commit war crimes, to unleash aggression, to rape, kill, and pillage. No duties of any president of the country has it part of the job description. I'm most grateful to our European colleagues who have stood so firmly with us. There's so much support issued for the support of the creation of the tribunal, the European Parliament, the EU, and some countries that have voted for the idea, in support of the irreversibility of punishment for the crime of aggression. We are hoping that the world can come together around the idea of irreversibility of criminal punishment for the prime crime. Today, we are discussing a number of practical models for the implementation of the tribunal, for its operation. Yesterday, comments were made by a number of keynote speakers. Indeed, they're models that give us a lot of optimism in that we will be able to prove the charges against specific individuals for the crime of aggression. And on the contrary, there are some other models that are fraught with high risks, that the legal assessment of the crime can evolve into intergovernmental conflict between the two countries. This is something we should prevent. The crime of aggression does not have the statute of limitations. It does not have any logical or illogical justification. The punishment has to come, and the punishment has to be swift. I am certain that if we can start up and launch the international mechanism, it will definitely sway the course of this aggressive war. Being realistic, just like yourselves, I don't think we can assure the physical presence of Putin before the tribunal. But let's agree that if we launch the mechanism, if we put this mechanism in place to limit the geography of his movements down to a handful of countries, if he dies in the status of recognized international criminal, then this tribunal has had its logic, then it has played its purpose. Thank you, dear colleagues. Thank you, Anton. Thank you so much. Thank you, Andriy, for saying these key words, why this is so important for all of us and the Ukrainian lawyers. We shall never tire or rest until we make the moment happen. When we see the progress already made in this year, the international law is very conservative, and here is just a blink in its development, but it's very inspiring with the progress we've made.
That while working on this, we have great friends, partners, and great colleagues in different spheres of legal profession who share our values, who share our approach, and who are with us in all these efforts and endeavors. And it's a big honor, and I'm really happy to give the next floor to our big friend, Professor Philip Sands, who was one of the main ideologists of this process, of this idea of the special tribunal. A year ago, Professor Sands published an op-ed in Financial Times why we need to establish the special tribunal. And exactly a year ago, on the 4th of March 2022, the event in Chatham House took place, and the London Declaration was being signed, which laid the foundations for this movement worldwide. So, Philip, it's a great pleasure to see you here with us online. We know that you would enjoy to be with us in Lviv, one of your favorite cities. I'm sure this time will come and we will meet here again. But please, from your perspective as an international lawyer, as an international law professor, practitioner, why you came up with this idea, why it was so important, and maybe your feedback on what results we got in this year of working together on this issue.
Well, first off, thank you so much, Anton, for the invitation, and to all the colleagues. I'm so sorry that I'm not with you in person. As you said, Lviv is not only one of my favorite cities on planet Earth, it also happens to be the birthplace of my grandfather, and I've been probably 25 times in the last 10 years, and I'm so sorry not to be able to be with you. So a couple of days after the war, the Financial Times got in touch and asked whether I would write 700 words on the subject of Ukraine and international law. I reflected on what I could most usefully write about. They had contacted me because I'm an international lawyer, as you mentioned. I've done a lot of cases on crimes against humanity and genocide. But also, as I described in my book, East-West Street, I had discovered that the city of Lviv, in which you are all sitting now, is the place of the origins, really intellectually, of two international crimes inscribed in the Nuremberg Statute and the indictment in 1945, crimes against humanity, really put into international law by the ideas of Hirsch Lauterpacht, a student at the University of Lviv, and genocide, which saw the light of day in a book published in late 1944 by Raphael Lemkin, also remarkably a student at the University of Lviv, although not at the same time. So there's a connection personally, but there was also a connection intellectually, and the reason for the FT to get in touch. I reflected on what to write about, and it struck me pretty quickly, and I don't think it's an original thought, many others will have had the same thought, that there is here a big gap in the international architecture. We have had, since 1945, 4 established international crimes. War crimes, the oldest of crimes, ironically with a very significant input intellectually and politically and diplomatically by Russia. Crimes against humanity saw the light of day in 1945. Genocide saw the light of day in 1945. And what used to be called crimes against peace, now the crime of aggression, also saw the light of day in 1945. It was clear to me that 3 of those crimes, war crimes, crimes against humanity, genocide, would be addressed fully and competently and well, both at the national level, Ukraine, but also in some other countries' national jurisdictions, but also, of course, most significantly by the International Criminal Court, which, following Ukraine's declaration, has jurisdiction, has competence in relation to those 3 crimes. But the International Criminal Court does not have jurisdiction over the crime of aggression. I regret that deeply, and I hope that one of the things, these terrible experiences that we're living through now, that you in Ukraine are living through now, will cause countries to reflect on whether they should revisit the circumstances in which the ICC will exercise jurisdiction over the crime of aggression and broaden that jurisdiction. But the fact was, there was a significant gap. And there was a significant gap in relation to a crime, aggression, which to my view is manifestly being committed. This is a completely unjustified use of force. It is not the exercise of self-defense. It is not authorized by the Security Council. It cannot be characterized as a humanitarian intervention. There is no possible argument to justify what is going on as a matter of law. And that makes the illegality of the war, and I believe the crime of aggression which ensues, absolutely central. It is the origin of all the other terrible things we have seen. You are living it in Ukraine. I, from a distance, observe it in my newspapers, on the televisions, on the screens. I've seen the terrible images from Bucha, from Irpin, from Mariupol. And it is right that the terrible crimes that appear to be being committed, certainly war crimes and crimes against humanity, I know there's also some who would say it rises to the level of genocide, will be investigated fully by the ICC and by other bodies and by national prosecutors and eventually by courts and tribunals. But the beating heart of the horror that is going on, the act but for which none of the other crimes would be taking place, is the decision to wage war. It's a leadership crime. It's a crime of aggression. It's a very small number of people around Mr. Putin and Mr. Lavrov and Mr. Shoigu, small number of individuals. And that, in this instance, is the catalyst for everything else. And what occurred to me back a year ago, and I feel even more strongly about it today, is that it would be a travesty of the idea of justice to find ourselves in a situation in 3 or 4 years' time in which we have investigations and prosecutions and maybe even convictions for individuals for war crimes and crimes against humanity, say in The Hague, perhaps low-level people, perhaps higher-level people. We don't know what the work of the ICC will bring. But to leave untouched the people at the top table. And in that regard, I think we all know, but the prosecutors in particular understand, that to tie the leadership to war crimes and crimes against humanity is difficult, it's not impossible, it's time-consuming, it's expensive, and it's slow. You can cut through all of that by putting the crime of aggression on the agenda, and that was what I wanted to do with that op-ed piece. I did not expect what followed. I did not expect the outpouring of interest from former British prime ministers, from leaders around the world, from Mr. Kuleba. I did not expect us to have that meeting at Chatham House a few days later, which I'm told is the largest meeting at Chatham House in the history of the organization in terms of the number of participants. Something plainly was happened. It touched a chord. So I was convinced then, and I'm equally convinced now, that if we avoid dealing with the crime of aggression, we risk avoiding justice in a real sense. We have to go for the top table where the decisions were taken. And in that regard, I was also very inspired by what happened in London in January 1942. The group of European leaders in exile, including, for example, Charles de Gaulle and various other leaders, came together and issued the London Declaration, the Declaration of St. James, on which, ironically enough, Mr. Kuleba, the foreign minister, had written a paper as a student of international law. He knew this subject very well. And they proposed the creation of some mechanism to deal with crimes perpetrated by the Nazi leadership. And of course, at the time in January 1942, everyone said, as many have said when I wrote my piece, well, it's a good idea, but it's never going to happen. But of course, it did happen. They said the same thing in relation to Serbia and Mr. Milosevic. They said the same thing in relation to Charles Taylor and Sierra Leone and Liberia. A great idea, but it's not going to happen. We don't know what the consequences of creating such a tribunal will be. We don't know what the consequences of issues, complex issues in relation to immunities and other things will be. But that should not deflect us from doing the right thing. Now, it is clear that there are complexities and there are issues to be addressed that are more of a political nature. There are elephants in the room. There are charges of hypocrisy, of double standards. Why were no tribunals created in relation to Africa? Why were no tribunals created in relation to Iraq? And I understand and I respect those arguments, but I don't think they deflect us away from what we need to do now in relation to the very same geographical territory in which the horrors of 1939 to 1945 were perpetrated. Whether the institution that is created is global or whether it is European, I think the right thing to do is to proceed with the crime of aggression and focus on the creation of an institution. There are complex issues to be worked out also in relation to the relationship, for example, of the work of the International Criminal Court. My own hope is that the ICC, which cannot exercise jurisdiction over the crime of aggression, nevertheless could find itself in a way to be a little bit more positive about this idea, because let's be frank, a special criminal tribunal for the crime of aggression is going to be addressed. We don't know exactly what its form will be. That needs to be elaborated. There are political issues to address, in particular with parts of the global south, and I am committed, as you know, Anton, to working with you on improving that relationship and that perspective. But my hope is that very shortly, perhaps even over this weekend, there might be an announcement following up from the European Union's decision to create a centre to investigate the evidence on the crime of aggression, to create an interim mechanism based in The Hague. Interim investigators, perhaps even an interim prosecutor, start now the work on the evidence and the identification. I think a special criminal tribunal on the crime of aggression is needed now. It would be a first since 1945. That's a reason for doing it, not a reason for not doing it. It underscores our commitment to the Nuremberg settlement. It underscores our commitment to the values and principles of justice in the round. It will require us, obviously, to work very hard on elaborating such a mechanism. But my passionate hope is that when that statute is adopted, finally, in the coming weeks or months, it might be adopted in the city of Lviv. Just as we had the London statute in 1945, I hope we will have the Lviv statute of 2023. recognizing the extraordinary place this city has had on the architecture of international justice and how the territory of Ukraine for more than 7 decades has been the font of international criminal justice. I'm not starry-eyed about challenges. I know that it's going to be tough. I know it's going to be difficult, but it is undoubtedly the right thing to do. And if we don't plug the gap on the crime of aggression, we risk undoing the system of justice, which I think everyone who's participating in this meeting is so committed to do. And I say clearly to you, Anton, and to your colleagues, you can count on my full solidarity and cooperation going forward. Thank you so much and good luck going forward.
Thank you so much, dear Philippe. It's really for us a big pleasure, and we are very happy to have you with us on these efforts, this our common efforts and common goal. And as I said, I'm sure that we will do that. It is important, I think, and for you personally, that yesterday in particular, Mr. President Volodymyr Zelensky mentions this issue of Lviv heritage, of Raphael Lemkin's heritage and legacy, of Hersch Lauterpach's legacy, and many other high-level participants today and yesterday and tomorrow will be talking about them. So please be sure that we here in Ukraine keep this heritage, keep this legacy. It is important for us. And I call on everybody in this room who hasn't done so, please read East-West Street, either in English or in brilliant Ukrainian translation. This is really excellent, excellent masterpiece. And maybe the last comment from my side, for the Ministry of Foreign Affairs of Ukraine, for the Minister Kuleba, the issue of special tribunal is one of the priorities. Just yesterday we had a important trilateral with Minister Reinsalu and Minister Hoekstra. We are now working on in order to engage Global South states to this process. So we are, of course, on this track. And in relation to London Declaration, I remember how we use it together with Minister in our advocacy work in relation to the establishment of the tribunal. Thank you, dear Philippe, once again. Dear colleagues, our next speaker on the panel is Mr. James Goldstone, who is Executive Director of the Open Society Justice Initiative, which is, of course, the leading expert organization and leading expert society, which advances the rule of law and rights protection worldwide through advocacy, litigation, research, and promotion of legal capacity. In particular, OSF has recently published very important materials on the issues of immunities and the availability of overriding the immunities, in particular, within the issue of choosing the right options and models to the prosecution of the crime of aggression. So, Mr. Goldstone, if I can kindly ask you, what is the position of yourself as an expert lawyer and the OSF, OSGI, in relation to how we can override these obvious elephants in the room, like immunities, and which ways are the most efficient ones to tackle the crime of aggression?
Thank you very much, Anton, for this opportunity. It's an honor to be here on this distinguished panel with these extraordinary experts in the room. Since the launch of Russia's full-scale military invasion of Ukraine in February of 22, there have been growing calls, and we've heard many of them just in the last several hours, for the creation of a special tribunal for the crime of aggression. Prosecuting Russian officials outside Russia without Russia's consent could implicate two types of immunities under international law. Personal immunity, which applies to certain high-level state officials because of the specific office that they currently hold, and functional immunity, which attaches to state officials more generally in respect of acts performed in an official capacity. Given its particular importance for the crime of aggression, which of course is a leadership crime, and in view of the limited time we have, I'm going to focus my remarks here on personal immunity and examine briefly how it may apply in the context of different models for special tribunals that have been discussed. Now, personal immunity applies to members of the Troika, head of state, the head of government, and Minister of Foreign Affairs because of the office that they occupy. The International Court of Justice has emphasized that personal immunity is not granted to these high-level officials for their personal benefit, but rather to ensure the effective performance of their functions on behalf of their respective states and to guarantee the proper functioning of the network of mutual interstate relations. In the arrest warrant case, the ICJ emphasized that Troika members enjoy personal immunity before the domestic courts of any state other than the state of nationality of the official accused, but only for so long as they hold the qualifying office. Personal immunity will not bar prosecution once the Troika member leaves office or where the state of the official waives immunity. Personal immunity applies to all acts, whether private or official, committed before or during the term of office of the high-ranking official. It applies to all civil and criminal proceedings, even for international crimes. And personal immunity means full immunity from criminal jurisdiction and inviolability. Prosecution, trial, and indeed the issuance of an arrest warrant against a state official may violate that official's personal immunity. But immunity does not prevent the law enforcement authorities of a state from investigating a foreign state official who enjoys personal immunity. Short of adopting any coercive measure, a foreign state may investigate the conduct of a Troika member suspected of having committed the crime of aggression. Now, what kind of court is an international court for the purposes of assessing whether personal immunity applies? In the arrest warrant case, the ICJ noted that personal immunity would not prevent the prosecution of an incumbent minister for foreign affairs, quote, before certain international courts where they have jurisdiction. Subsequently, the appeals chamber of the Special Court for Sierra Leone and the appeals chamber of the ICC have both found that the personal immunity of a head of state does not apply to the prosecution of international crimes before these international courts. The two appeals chambers each emphasize the distinction between international and domestic courts. Neither the ICC nor the SCSL appeals chamber offered a definitive list of criteria which a tribunal must present to be considered international. However, the decisions highlighted two key considerations. An international court acts on behalf of the international community, and it exercises jurisdiction on behalf of a multiplicity of states. The ICC appeals chamber reasoned that personal immunity does not apply before international courts because international courts have a so-called different character compared to domestic courts. Whereas domestic courts are an expression of a state's sovereign power, which of course is limited by the sovereign power of other states, international courts act on behalf of the international community as a whole, and so international courts, when adjudicating crimes on behalf of the international community, are not constrained by the par in parem principle, which prohibits one sovereign from standing in judgment over another. The second criterion of an international court before which personal immunity would not apply is that it exercises jurisdiction on behalf of multiple states. The fact that the special court in Sierra Leone was not a state organ and not exercising jurisdiction on behalf of Sierra Leone was relevant in determining that it was an international court. Now, the number of states on whose behalf the international court must exercise jurisdiction is less clear. The ICC appeals chamber did not, for example, explain how a tribunal can be shown not to act on behalf of a particular state or states. Now, these decisions illustrate that there are different types of international courts. According to a concurring opinion by 4 ICC judges, an international court may be regional or universal in orientation. It may be ad hoc or permanent in duration, and it may apply civil or criminal law, public or private international law, or any combination of these. An international court does not lose its character, this opinion said, as such, merely because its work requires it to apply the domestic law of one or more states. So let me briefly turn to the different models for a special tribunal and consider in particular the extent to which each is likely to be deemed international for these purposes. If the special tribunal is established following a UN General Assembly resolution, it would have the strongest claim to the status of being an international tribunal. This is not because the UNGA, as the UN Security Council does, has specific legal authority to create an international tribunal, but rather because the General Assembly, with 193 UN member states, has the widest possible membership. In the absence of a General Assembly resolution, a regional tribunal established by an agreement between Ukraine on the one hand and the European Union or the Council of Europe on the other may present some claim to the status of being an international tribunal. A special tribunal established by agreement between Ukraine and the Council of Europe may have a stronger claim, given the Council's larger membership including Ukraine's currently and Russia's formerly. A special tribunal established by agreement between Ukraine and other individual states would likely present a relatively weaker claim to the status of being an international tribunal, particularly if we're talking about a very small number of other states. And finally, a special tribunal established as a Ukrainian internationalized court without significant involvement from the international community would likely present a relatively weaker claim as well, depending on the tribunal's exact format and nature. That said, some have argued that there is nothing to prevent the United Nations General Assembly from endorsing the creation of a hybrid tribunal rooted at least partly in the Ukrainian national system, and that such General Assembly backing could be sufficient to provide the international status necessary to overcome immunity. Now, in closing, I'd like to just step back and observe that while there is widespread assumption in some quarters that countries in the global south are not supportive of an international tribunal on aggression, that idea has not been fully tested yet. There is more work to do, as we have been hearing. We must broaden the group of stakeholders involved in the creation of a tribunal. And to bring others on board, my own belief is that states must do two things simultaneously. First, establish a tribunal that responds to the singular nature of Russia's brutal and unprovoked aggression. And secondly, reaffirm in a meaningful way that the norm against aggression is a universal one that applies to all states and their leaderships equally. Thank you very much.
Thank you very much, Jim, for your expert advice and your position. I'm sure that together with our partners, we will be able to tackle and overcome all the issues and find all the solutions. And yes, it is very important to engage the Global South, and we are working now on this. This is a task from Minister Kuleba, and we are looking forward to working with our partners and on getting this broadening of support. And the next speaker on our panel is Mr. Frank Hofmeister from Brussels. He is a Director General for General Affairs and Chief Legal Officer of the Secretariat General of the European External Action Service. And also he serves as a professor of the Institute for European Studies of the Free University of Brussels. He has PhD from University of Heidelberg and works within the European Commission for many years, since 2001. So it's great to see you with us, Frank. Thanks for joining. And my question will be, of course, to you as a representative of European Union External Action Service on what's the European Union's position, why accountability mechanism for the crime of aggression against Ukraine is important, what is the position of EU, how this should or may be done, and your position on the importance of establishment of the International Center for the prosecution of the crime of aggression committed in Ukraine. Frank, the floor is yours.
Thank you very much, dear Anton, and I would like to echo Philip's sentiment. I would have been happy to be in presence in Lviv, the capital of international criminal law, so to say. But for practical reasons, you have to bear with me online. Anton, you have asked for the position of the European Union, and I would like to stress that the Ukraine initiative to create full accountability has met great sympathy by all member states of the European Union. There were preparatory talks between Foreign Minister Kuleba and many of our foreign ministers. There were talks at the highest level, and also the esteemed advisor of President Zelensky, Mr. Smirnov, directly talked to the legal advisors of the ministers of foreign affairs to explain the Ukrainian position. And I think that was very important to bring the ball rolling. And one of the results of these activities was that it went into council conclusions at the highest level. And so the European Council, the heads of states and governments, in December, by unanimity, found that there shall be full accountability, including for the crime of aggression. This is a very significant statement. So there's no question anymore if to do something, but the only question is how to do it. And in this respect, the European Council also mentioned that the EU gives full support and trust to the International Criminal Court, which means that, as Professor Sands has explained, all the investigations on the other three core crimes, crime against humanity, war crimes, and potentially genocide, will have to be carried out in full speed and should not be hampered by any parallel efforts. And next step, which we have seen in a very short time, was in February this year, that during the EU-Ukraine summit in Kiev, the Union could announce its full support to the prosecution side, the International Center for the Prosecution of Aggression, and we heard more details yesterday and certainly over the conference. And this is a very significant step because national prosecutors who are already looking at it on the basis of universal criminal jurisdiction in their national law will group together and will be supported by Eurojust, technically, financially, locally, to preserve and establish evidence of this horrendous leadership crime. And we consider here that this is already a very strong political signal right now, here and now, that there will be accountability on the crime of aggression. So I think we can say the efforts of Ukraine in that respect have already borne fruit with very concrete action I've just mentioned. What needs to be done next, dear Anton and dear audience, is of course to find out the precise modalities of the tribunal itself. And here Ukraine has assembled a group of supporting states, so-called core group. I'm happy to say that roughly 30 states already are on the list. And as you've underlined, Anton, it will hopefully also find support by some states in the so-called global south. And from our perspective, it's a good idea to reach out and explain more in detail what could be the modalities of such a tribunal. And the task now before us is both a legal and a political one. The lawyers need to hammer out a solution which is solid and which will tackle the problems identified by Mr. Goldstone and Philip Sands and Mr. Smirnov. At the same time, there needs to be sufficient political support. It is not in anybody's interest if you go back to the General Assembly later on in the year and there would be a significant decrease in support. Therefore, the double challenge, legal solid and sufficient political support, will be before us. And I'm happy to say that European Union and our member states are courageous to take on the challenge. I think the Foreign Minister of Estonia was very clear about the position of his country. Many other countries feel the same, and therefore I'm confident that this year we will have further progress on hammering out a solid and politically legitimate solution. I think with these remarks, I give the floor back to the conference in Lviv. Thank you so much.
Thank you so much, dear Frank. We are, of course, happy to work with the European Union, with our colleagues from European External Action Service, European Commission, in particular DG Justice, of course. And we will be back, of course, with all the questions in relation to the special tribunal itself, because, of course, the ultimate goal is the establishment of the special tribunal. But as we mentioned here today during the conference, these intermediate results are very important. So, and deliverables in particular of this conference, that today here, the agreement will be signed that the UA-JIT joint investigation team will start working on the crime of aggression against Ukraine, and the International Center for the Prosecution of the Crime of Aggression will be launched. This is a practical deliverable of this year of work, and in particular of today's conference, and we are more than happy that prosecutors will have this tool and instrument to work with. And we are sure that full and or comprehensive accountability must be ensured, and it cannot be ensured without accountability for the crime of aggression against Ukraine. And for us here in Lviv, Kyiv, Kharkiv, Odessa, Izum, Bucha, it is very important to understand that the question is not if, that there is no such question as if, that the question is that we need to have progress, and we need to have the final accountability mechanism, special tribunal for the crime of aggression established. So thank you once again, Frank. And I'm more than happy to pass the floor to our next speaker, our big friend and supporter, and one of the leading academics on international criminal law, and in particular on the crime of aggression, Professor Klaus Kress, who is a professor and director of the Institute of International Peace and Security Law in the University of Cologne, a professor of international law and criminal law, holds the chair for German and international criminal law, and is, as I said, one of world's leading experts on the issue of the crime of aggression. We are very happy to have Klaus with us from day one. So Klaus, your position as a leading academic, why the world, the international community needs the establishment of the special tribunal for the crime of aggression, and how and why the world needs to do that.
Thank you so much, Anton, and thank you so much, Mr. Chief Prosecutor, for what is really a truly impressive conference. I feel honored to be here, and I feel humbled to address this audience here for two reasons. Let me say this at the outset. First, it has been mentioned, but as a scholar of international criminal law, I should say it again. I'm humbled to speak at an intellectual birthplace of the entire discipline. And I'm also humbled to speak here as a German citizen. I'm fully aware, as I'm speaking, fully aware of Germany's egregious wars of aggression and of the fact that Ukrainians have been suffering terribly. And I'm making that point not just, but importantly, because I'm humbled in looking back to this and very acutely aware of the memory, but also because you mentioned Nuremberg, and you, Mr. Minister, you spoke about what possible effect this could have on the Russian population. Let me be very clear as a German citizen. Honestly speaking, it took us a while, former generations, to embrace the Nuremberg legacy. It would be dishonest to ignore that, but we eventually embraced it. And I can say it has proven a gift for our collective memory, for how Germany looks back to the darkest hour of its history. And so, in a sense, we have some precedents of how this can work on a level which is far more fundamental than legal technicalities. Now, let me, in the few moments I have to address this distinguished audience, address two issues. First, why is it so fundamentally important that the crime of aggression is not left out from the picture? And second, what's the preferred, in legal and I also think political terms, the preferred avenue to make it happen, the establishment of the special tribunal? Russia's ongoing war of aggression against Ukraine is a terrible attack on this country and its people. And we are feeling with the Ukrainian peoples every day and every hour as it so sadly continues to unfold. But let us be clear, it is at the same time a fundamental assault on what the International Court of Justice has called a cornerstone of the international legal order, the prohibition of the use of force. A war of aggression is the most serious conceivable violation of this cornerstone. And there is, within the architecture of international criminal law, one crime by which the international community can specifically react to this violation. And that's not war crimes, crimes against humanity, genocide, as important as they are. The crime that has been, so to speak, set in place by the creative precedent in Nuremberg, this crime's ultimate purpose is to protect the prohibition of the violation of the use of force, to provide it with resilience. And I think there has been, after the entry into force of the United Nations Charter, never been a moment where this resilience is so much needed. But to those of you to whom that sounds a bit abstract, I wish to get a bit more concrete in order to show why, while war crimes, crimes against humanity, genocide are so important, and nobody would deny it for a second, it only covers part of this deep injustice that we are currently experiencing. When we opened this panel, we all paid tribute to the victims of this ongoing war. Part of those victims, very importantly, are the countless Ukrainian soldiers who lost their lives during the battle. But as we know, as we all know, international lawyers, killing combatants during the course of hostilities does not constitute a war crime. It cannot be prosecuted as crimes against humanity for good reasons within the system of international criminal justice. There is only one crime, the crime of aggression, that can cover this part of the injustice. And nobody should deny that those brave soldiers who lose and have lost their lives are not victims of this overall injustice that we are experiencing. This is why I have been from the beginning doubtful about this distinction between atrocity crimes, war crimes, crimes against humanity, genocide on the one hand, and then the crime of aggression, which has led to a marginalization of this crime. No, a war of aggression as we are experiencing it now is an atrocity. Now, about the second question, how to establish such a tribunal. There are a number of models, but it seems to me, as I'm following the diplomatic conversations closely, there are currently two models which are most prominently in the alternative there. A model which is widely referred to as a hybrid model, which is, in my view, speaking as a scholar, not altogether precise, because what people so far have meant in referring to it is basically a Ukrainian tribunal, and very importantly, applying Ukrainian national law. And the alternative to this would be an international special tribunal. I leave aside for a moment a European solution, but focus on the solution you have, and I think very rightly put in the foreground, a tribunal established by a treaty between the United Nations and Ukraine, with the Secretary General acting on behalf of the United Nations and mandated, requested to do so by the United Nations General Assembly. Now, why am I very reluctant as far as this hybrid Ukrainian solution is concerned? Not because of any kind of disrespect with respect to the Ukrainian national system, not because I deny the virtues of local justice being close to the victims, but for very specific reasons here in this case. One reason has been pointed out by my distinguished colleague James Goldston, and I will use his terms to formulate it cautiously. The issue of personal immunities, the application of personal immunities before a essentially Ukrainian national tribunal will be stronger in view of the applicable international case law in place. So a tribunal rooted in the Ukrainian legal system, applying Ukrainian law, this will be a more difficult call when it comes to personal immunities. And that's not a minor point, because President Putin is, let's face it, the main person under suspicion here. So the question whether he enjoys personal immunity or not is a problem of real practical significance. But there is another point, and this is a point when what we should do, look also what this exercise can bring to the world in terms of prevention. You, Mr. Minister, you have very rightly said it is about justice now, but at the same time we should not look at it in isolation. It is also a very important undertaking for how the international legal architecture evolves. And here it is important to send out the strongest possible international signal for the revalidation of the prohibition of the use of force, which is of a universal nature. Frank Hofmeister has just reminded us about the statement of the heads of states and governments within the European Union. They have said in this important statement, the prosecution of crimes of aggression is in the interest of the international community as a whole. That's the consensus, and remarkably and positively so. But this, of course, is most powerfully reflected by the establishment of an international tribunal with the endorsement of the UN General Assembly. And such a tribunal should apply the internationally agreed definition of the crime of aggression, which, after all, is in the ICC statutes. So hereby, it will also strengthen the authority of this definition, of this court, in the long term. This makes a huge difference. This is the current definition on which we have worked for more than 20 years, which has been, it is a compromise in the end, but it has been accepted. It has been, and I stress this point, it has been accepted by Russian delegates as well. They are on record with being fine with this definition. So why not applying it now at a moment of dire need? Last point, of course it is crucial here to engage with the global South. Of course the global South will have legitimate questions. And one important question will be, is it just about this horrible war of aggression, or are you serious and genuinely interested in strengthening the international legal architecture beyond? And it is my deep conviction that one will be the more persuasive in those engagements with the global South, which, as James Goldston has said, have not really begun so far. They should begin. But you will be the more persuasive, the clearer and the more credible you signal it's not just about this war. It is an exercise to fill, as Philip Sands has said, a significant gap in the international legal architecture. Now we start, but we want to make it consistent and apply it consistently. Consistency in international criminal law is key because this is the fundament of legitimacy, and legitimacy is the key currency in international criminal justice. So we have to be serious about this, and this means we should also be honest and serious about the gap at its roots. That's the gap within the ICC statute, which Philip Sands has deplored, and I hasten to join my voice to his. I do deplore this gap as well, because no doubt the ICC would be the ideal institution to deal with this challenge. So we should pursue a, so to speak, a two-track strategy, working with highest speed possible on the establishment of an international legitimate special tribunal, and also take the more burdensome longer-term perspective, but doing it genuinely to close the gap where it exists at its roots in the ICC statute. Thank you very much.
Thank you very much, dear Klaus, for your friendship, for your support, and for making this, I think, very important notion that actually the crime of aggression and accountability for it is one of the instruments which brings accountability for the losses of Ukrainian soldiers and officers who lost their lives in this war of aggression. Because really other mass atrocity crimes cannot cover this issue. Dear colleagues, we are running till the end of our panel, but looking at this distinguished gentleman, I may not lose this opportunity to ask you whether you may have some questions to them in order for them to give very brief answers. If the audience have them, or if not, then of course we have a day of conference today. Half of the day tomorrow we'll be able to do that. Mr. Kostin, of course, please.
I am extremely grateful, colleagues, for you all, and I wanted to say this at the beginning, at the opening, that, and this is now the proof, everything I'm talking about at different events, at my meetings, bilateral and others, I hear now from you today. And this is for me the most important signal that we are on the one page, on the same page. We have the same arguments to deliver. And from my point of view, it's important for all of us to be even more active in our communication, because all of your arguments, dear colleagues, they're absolutely strong in order to persuade those from all civilized world who knows that the act of aggression was committed, to persuade them to be brave and to make a second step, to take political decision and to join our tribunal in order to fill in the gap you have mentioned, not only for Ukrainians and for Ukraine, and not only in memory of Ukrainian soldiers, but also for our future generations. I will tell two small things. First, maybe many of you remember, I think all Ukrainians remember, that people of Ukraine started to give name for the future tribunal. And the first name given by people for the tribunal was, who remember? It was Kharkiv Tribunal. After, at the last days of February, Russian army start to hit residential buildings in Kharkiv just by missiles. And Ukrainians who were at that first day of full-scale aggression, they calling for tribunal, they start to name it Kharkiv. Then
we were talking about Mariupol tribunal. Then after liberation of Kiev region, it was Bucha tribunal. And maybe there were some other names. But now, after all atrocities committed, not only in Kiev region, but after we liberated Kharkiv and Kherson, the same atrocities committed there, the same pattern of conduct. Now Ukrainians need this tribunal in order to feel that justice is in place, that justice exists. And this is maybe a political statement, but behind this political statement are lives and destinies of hundreds of thousands of Ukrainians who lost their relatives, who lost their homes. But I would say for all of Ukrainians, because all Ukrainians suffered from this war of aggression, even those whose relatives are alive, even those whose property is not destroyed, but all of us. And I would say even more, when I come to Europe, when I come to the United States, and when people from their countries, from these countries, start to discuss the problems they have in economy, gas prices, inflation, etc., and I start to talk to them and say, look, you are also the victims of this war of aggression. And it should be our collective response in order to fill this gap and to punish the leadership of Russia now. And I absolutely agree to create the efficient system for the future. And I'm very grateful for these words of two parallel tracks, because what we are doing is not only for us today, this is for all future generations of all civilized world. I'm very grateful. I'm sorry, it was not a question, it was just a message, but I thought it was important. Thank you so much.
Thank you so much, Mr. Kostin. I think that there couldn't have been a stronger point to end this panel discussion than these words by Mr. Prosecutor General. I think that this is a plea of all Ukrainian nation, both political and legal. They are undividable in this case. And to wrap up, I really want just briefly to say that when we look back at this issue and a year of work on it, I think that we are all proud of these intermediate things which we already got and which we have now due to the job of many people present in this room in particular. All these political resolutions of support from the European Parliament, Parliamentary Assembly of the Council of Europe, other parliamentary assemblies, national parliaments, this is a huge thing. So this means that the issue cannot be neglected because there is the query for this issue. The establishment of International Center for the Prosecution of the Crime of Aggression, ICPA, which Mr. Kostin will sign the agreement today with his distinguished colleagues. This is a historical moment. And I think Ambassador Van Schaak was speaking about that yesterday. The first ever real international effort for investigation and prosecution of the crime of aggression after the Second World War. So here in Lviv, this history is being made up. And also the issue of the core group, which I'm sure together with our partners we will enlarge, we will broaden its membership. And this all is done with a big endeavor and effort of the whole Ukrainian nation to bring justice, to bring accountability, and we are sure that justice and accountability cannot be done for all of us without the accountability for the crime of aggression. This panel today represented huge legacy, huge ownership of the people who are really engaged in this job. And it's a big honor and privilege for me to be a moderator for this brilliant, distinguished gentlemen. I want you to give a round of applause for them.
Thank you. Thank you very much. Gentlemen, thank you very much. We need to finish our discussion.
One more thing. On Global South, in many times it has used like excuse. We are out of Global South support. But let me stress, I have found clearer position by many Global South colleagues than by some Western colleagues. Guatemala colleague said he wants to organize in Latin America core group meeting. And let me say that there is a particular responsibility on these countries of our like-minded values community who belong to the Security Council. Their leadership we are expecting and delivery policy. United States, United Kingdom, France. Thank you.
Thank you very much. Thank you very much, Mr. Rinsalo. Dear participants, now we will have a 20 minutes coffee break. And after that, we will be joined by very special guests. So I'm kindly asking you, don't be late. We will continue at 11 a.m. Thank you.